The responsibility for making arrangements for your children is yours. Remember, depending on the nature of your matter, you may be in mediation for a long time. You should dress properly when attending mediation or visiting the offices of the Commission. Dress as if you are going to an important meeting or an interview. You should not wear short sleeves, tank tops, short pants, short skirts, slippers, hats, or sunglasses. When you attend mediation, you should bring all the evidence and documentation you will need on that day to support your position when discussing the issues with the other parties. This includes any photos, documents, and exhibits you believe will be important in resolving the issues between the parties. At the mediation session, you will see the mediator and the parties to the dispute. The parties may represent themselves or be represented by an attorney or another person who has been granted authority to settle the matter on their behalf. No one else can attend a mediation session without the permission of all the parties and the mediator. Before mediation commences, the mediator will assist the parties to set out the ground rules for the discussions. This means the parties will agree to a code of conduct for the mediation session. The purpose of ground rules is to ensure that each party feels comfortable during the mediation and is given a fair chance to communicate their side to the other party. Ground rules can cover issues such as vulgar or abusive language, threatening or disruptive behavior, the order in which parties will present their side to the other, and the use of cell phones during mediation. Remember, these are only examples of some of the issues that can be dealt with in the ground rules, and the mediator will help the parties ensure that all relevant rules are established. Rules can, however, be added as necessary as the mediation progresses. The function of the mediator is to help ensure that each party is comfortable enough to present his or her side and does not unduly hamper the other party in expressing their point of view. Thus, to achieve this, it is sometimes necessary for the mediator to hold a caucus with one of the parties. A caucus can be held at the request of either the mediator or a party. A caucus is a private meeting between the mediator and one of the parties to work out problems that occur during the mediation process. This may include an opportunity for the party to vent issues or build up emotions without aggravating the other party and jeopardizing the negotiations. Caucuses can also be used to clarify misconceptions or to help the party change unproductive or negative behavior, or even to limit disruptive communications between the parties. It is your responsibility to ensure that you are prepared for your mediation session. Read all paperwork carefully. Be sure you pay close attention to all deadlines and to all the procedural steps you must follow. The Environmental Commission is a court and must remain impartial. The staff of the Commission cannot give you advice on what course of action you should take at any stage of mediation. However, the mediator will be there to help all parties through the process. If you are not sure what to do, it is always advisable to speak to an attorney. They can advise you how you should proceed with your matter, even if you are representing yourself in your mediation session. Resources are available at the self-represented litigation centers, and the main one is at the Commission's library. These include other materials specifically designed to help you understand the mediation process at the Commission. Other resources are also available on the Commission's website. English is not your first language, or if you need an interpreter, you will generally need to provide one for yourself. You are advised to select an interpreter who will be able to understand and translate legal and technical terms which may arise during the proceedings. Mediation can come to an end if the parties arrive at an agreement resolving some or all of the issues in dispute. The mediation agreement will then be reduced in writing by the parties with the assistance of the mediator. The parties will be bound by the terms of the agreement. Mediation can also come to an end if the parties are unable to reach an agreement, or if any party withdraws from the mediation by informing the mediator he wishes to do so. The mediator also has the discretion to terminate the mediation if he or she has good reason to believe that resolution of the dispute is unlikely. Once mediation is concluded, whether successfully or unsuccessfully, the mediator will inform the presiding member in the matter that mediation has been concluded. The mediator will not reveal anything further with respect to any agreements arrived at, anything said during the mediation, or the behavior of the parties. The mediator will return to the parties any documents or exhibits which have been provided to him. He or she will also destroy any notes taken of the proceedings. When the parties next appear in court, they will inform the court of the outcome of the mediation. If a mediation agreement resolving only some of the substantive issues of the matter has been reached, then the court will proceed with the hearing of the remaining issues. If the agreement resolves all the substantive issues of the matter, then the parties have two options to end the formal litigation proceedings. The option chosen will depend on what has been agreed between the parties in mediation. The first option is for the parties to formally discontinue the matter. The second is to seek a consent order of the court in terms agreed between the parties in the mediation agreement. The Commission will usually grant such an order by consent, provided that the terms of the draft order are in accordance with all relevant provisions of the law and are just in all circumstances. This may not be on the same day the parties apply for the consent order, and the court will let you know when its decision will be delivered. The final outcome of the matter will be recorded in a written order of the court signed by the registrar, and a copy of this will be served on all the parties to the proceedings. You should remember the following guidelines. Be on time for your mediation session. Dress properly. Be prepared to present your side of the case. Even while your matter is being mediated, there may still be deadlines you will have to meet for the trial of your matter. Be sure you comply with all the instructions of the court. It is always advisable to seek the advice of a lawyer where possible. The mediator is there to assist the parties in arriving at a mutually acceptable agreement. So if you are in doubt about anything about the mediation, you should feel free to ask the mediator. The Environmental Commission has prepared materials and other resources to assist you in preparing for your mediation session. These are available at the Commission's offices and on our website. If you follow these guidelines, you will be better prepared to participate in mediation, and the Commission will be better able to deal with your matter efficiently, expeditiously, and fairly.